All right, you can be, we're good to go.
Great, welcome. I'd like to call the Cavan Monaghan Accessibility Advisory Committee meeting to order on July 23rd at 1 p.m. First, I'd like to read the land acknowledgement. We respectfully acknowledge that the Township of Cavan Monaghan is located on the Treaty 20 Mississauga territory and the traditional territory of the Mississauga and Nishnawbe. We offer our gratitude to First Nations for their care for and teachings about these lands. May we honor these teachings. The next item in the agenda, the next is the approval. So I'd ask for a mover and a seconder to approve the agenda as presented. Paul. And Leslie, great, thank you. The next item is a disclosure of pecuniary interest. So this falls underneath the Municipal Conflict of Interest Act, which governs this process. Throughout this process, we'll speak to the personal or permanent, let me start that all over again. I wrote a script and I'm trying to follow it. The Municipal Conflict of Interest Act governs the process regarding pecuniary interest and if there would be a personal financial interest in the outcome of the decision. John will speak more to that process during our orientation and training session. We'll turn that over to our presentation. Welcome, John. And we will get started.
Thank you. Let me do that.
Not a formal one, okay.
Good afternoon, everyone. Thank you for joining. My name is John Pappas. I'm a lawyer here in Burles in Toronto. My practice is focused on municipal law, and I assist the township with a number of different matters, a range of different matters, including some governance training as well. So today, the overview of this presentation is meant to assist the members of the committee in understanding the role of the committee and some few important governance doctrines and laws that will apply to the committee and its work. So we'll start with an introduction of the committee and its role under the Accessibility for Ontarians with Disabilities Act, or AODA. You'll hear me refer to it as AODA. In part two, we'll talk about roles and responsibilities in municipal government. So it's important to understand the broader picture before understanding what it is this committee's role is within that broader framework. So a bit of an overview of the various branches or divisions within a municipal corporation and how it all comes together. We'll then talk about the role of the Accessibility Advisory Committee in a lot more detail. And then lastly, we'll end on some important governance principles. First, dealing with committee meetings, how they're structured, how they run, and a bit about the open meeting rule, which applies to this committee. And then we'll end on municipal ethics. So these are rules of ethical conduct for members of the council, members of advisory committees, as a representative of the public. I was waiting for my let me to move in. And then we did. Or AODA, right, the Accessibility for Ontarians with Disabilities Act, is a statute that's been around for 20 years now. And it was originally passed with the goal of eliminating all barriers for individuals with disabilities by the year 2025. And here we are in 2025 with still a lot more work to do in the province. According to the province, more than 2.6 million individuals in Ontario live with a disability, and many face barriers in their daily lives, accessing services, using public facilities, accessing public transit. And that's why the province passed this legislation. So there are two critical components to how this legislative regime works. First, there's AODA, which is the statute that's been passed by the legislature. That statute doesn't necessarily set out accessibility standards in and of itself. What it does is it sets out a process for how we develop and work toward achieving accessibility and inclusivity. There are a number of requirements that are imposed on public sector bodies like municipalities, and there are also rules for reports that have to be made to the province. The bulk of the substantive standards come through a regulation that's made under AODA, and that's OREG 191/11. It's called the Integrated Accessibility Standards, or AIS, you might hear it called as well. That sets out some procedural requirements for certain public sector organizations in adopting or considering certain facilities that are put in place. And it also sets out some substantive accessibility standards as well. Municipalities in Ontario, of course, you think of, I often liken municipalities as the level of government that's closest to the people, or where the rubber of governance hits the road, because it's quite true. Every day, when you from the time you wake up to the time you go to bed, you engage with services that are provided by municipalities countless times in a day. And with that, municipalities play an incredibly important role in improving accessibility for those that reside in their communities. Some examples of the higher level things are community centers and libraries, but even more simply is the way sidewalks and roads are designed and laid out, as well as public transit. Under AOTA, the township also has an obligation to prepare and provide to the province what's called an accessibility report, highlighting its work that it's done to address accessibility barriers within the township. And in addition, and here's where the role of this committee comes in, AOTA requires municipalities that have a population of over 10,000 residents to establish an accessibility advisory committee. And that's exactly what the township did in 2024 when it passed terms of reference to establish this committee. And I think the terms of reference are included in the agenda package. That's provided for your reference, for your benefits. You can take that home and digest it a little more. I'll cover quite a fair deal of what's in the terms of reference in our presentation today. Yeah. Oh, sorry, but one. There we go. Great. So the Accessibility Advisory Committee, or I'll call it committee for short, plays an important role in supporting council decision making that works toward achieving accessibility and ensuring that services and facilities provided to the public are done in an accessible manner. Members provide advice to council. So through this committee, advice is given to council based on lived experience of individuals, community engagement, or feedback from the public that's received by the committee. Under the legislation, there's no fixed number of members, but the majority of persons on the committee must be individuals with disabilities, as it's defined under AOTA. So the Townships Committee, based on the terms of reference, is comprised of up to 7 members. There can be 3 to 5 members of the public, 1 township staff member, and 1 member of council. So as a member of this committee, your term of office under the legislation is fixed with the same term of this current council. So 2022 to 2026. So the term of office will end November 14th, 2026. Members will continue to serve on this committee until their successors are appointed, but members are also eligible to be reappointed in the next term of council. Members will be working very closely with township staff on a range of matters. So for meeting logistics and agenda items and circulating the agenda, the township clerk will be liaising with committee members, and that includes scheduling and agenda distribution. And other township staff and other departments that may have matters that come forward to the committee will also be involved in reporting to the committee and relaying advice or relaying certain information from committee to council, council to committee, based on their departmental needs and what their work plan looks like. So that's our 30,000-foot overview of where we are. And so we'll start with now our roles and responsibilities in municipal government and a municipal corporation. So starting off with what a municipal council is, we often think of council, city council, township council as the decision-making body in a municipality. And that's because under the Municipal Act, which governs municipal corporations, the powers of a municipality must be exercised by its council by bylaw unless otherwise provided for. In comparison to other levels of government, so provincial, federal levels, where we think of very clearly, you have the legislature, so the Ontario Legislative Assembly or Parliament, and then you have cabinet. That division doesn't really exist in the municipality because council exercises a range of different functions. They provide executive decision-making, legislative decision-making, so making laws, and also exercising some quasi-judicial powers when they have hearings. So as an elected assembly of individuals, council makes decisions by collective decision-making or voting. No one member of a municipal council has authority to bind the corporation. The only exception to this is when they act when they act together with a quorum or a majority of other members at a duly constituted meeting of council. Council provides direction and guidance, and they set policy directions, or it sets policy directions, but council is not involved in the day-to-day administration or operation. That's where municipal administration comes in. Municipal administration, or the staff, township staff, and its various departments, they're vital to the public municipality, obviously, because as a corporate entity, you need to act through individuals to provide services, answer the phones, those sorts of things. Professional municipal staff provide objective information and advice to council on its decision-making process, and they also carry out programs and services based on the direction given by council. So the role of municipal administration is to implement council's decisions and establish administrative practices or procedures for how staff are going to implement those decisions, undertake research and provide advice to council on a range of policies and programs, and carry out other statutory duties that might be assigned to a particular staff member. For instance, the clerk, the municipal clerk has certain duties. So then comes committees. Committees can take a number of different forms, and that depends on how they're constituted and the authority under which they're created. They can be committees of council. So in a number of municipalities, there's often, for instance, a planning and housing committee or transportation committee. There can also be ad hoc committees to study a particular issue or a particular project that requires closer attention. And then the last category are advisory committees. And this is exactly what this committee does. It's an advisory committee of council established by or required to be established by statute. The role of committees generally is to deliberate very specifically on a subject, topic, or project and provide advice to council to inform council decision-making on specific matters, and depending on the terms of reference of that advisory committee or any specific direction that's given by council to consider certain matters. In a municipality, council is the ultimate decision maker, as I mentioned. So committee decisions don't necessarily bind a municipality unless expressly provided for by law, but they go to informing the overall decision-making process of the municipality. Three roles and responsibilities. So the overall role of this committee is set out in AOTA. And these are excerpts or modified excerpts of what the statute says the committee's role is. Overall, it's to provide advice to townships council and administration on a range of municipal processes and programs to make municipal services more inclusive and accessible to individuals with disabilities. The duties of the committee, as I mentioned, are set out in AOTA as well as in terms of reference. And the AOTA describes the committee's role as follows. It's to provide advice to council about the requirements and implementation of accessibility standards. So those are the standards set out in the AIS, the regulation, or sorry, IAS, the regulation. Prepare the accessibility report of the township and such other matters that council may seek its advice on. So this is the omnibus provision or the general provision where council might be engaging in a project or considering a facility and will require some advice or some input about how to make that program or facility be more accessible to individuals with disabilities. Under the legislation, the committee also has a role in reviewing site plan application drawings that are submitted under the Planning Act that the committee selects for its review. And I'll speak to that in a little bit more detail shortly. And then lastly, to perform all other functions that are specified in the regulations under AOTA. I'll speak shortly about the AIS requirements, but there are a number of things that a council is required to consult on in the process of decision-making, consulting with this committee. So under AOTA, Township Council has corresponding obligations to the committee. The committee serves a function. Council also has certain obligations. Under AOTA and the regulation lead under it, the IAS, council has an obligation to seek advice from the committee on the accessibility for persons with disabilities to buildings, structures, and premises, including ones that the township purchases, constructs, or renovates, ones that the township leases, and ones that are provided under what's called a municipal capital facilities agreement. Essentially what that is where a developer or private sector actor develops some facility but wants to make part of it accessible to the public for municipal needs. So in this bailiwick or in this bucket of obligations, council has an obligation to consult with the committee to gain that input, that vital input that council might not necessarily have the ability to do within the confines of a meeting. Council also has an obligation to provide the committee copies of site plans selected for review, which again we'll talk about very shortly. Council must also consult with the committee on a range of different matters that are set out in the regulation. And this includes establishing, reviewing, and updating the township's multi-year accessibility plan. And that, I believe that's available on the township's website, but it might be a good idea to circulate to the members so that the members have an opportunity to see what that document looks like and review it. In addition, developing accessible design criteria in the construction, renovation, or placement of bus stops and shelters within the municipality, determining the proportion of on-demand accessible taxi needs within the municipality, the need, location, and design of accessible on-street parking spaces when the municipality is building new or making major changes to on-street parking, And then lastly, one that I think is pertinent to this township, when building new or making major changes to existing recreational trails to help determine particular trail features in areas of rest, for instance. In addition, the council must consult with the committee on the needs of children and caregivers with disabilities in the community when building new or making major changes to outdoor play spaces. In addition to the design and placement of rest areas, as I mentioned, along exterior paths of travel, when building new or making major changes to existing exterior paths of travel. So this can include, in some circumstances, a sidewalk or a trail. So there are a range of matters that council is required to consult with the committee on, and I want to tell you a little bit about how that consultation works in the context of a council and a committee relationship. So as I mentioned, council makes decisions as a whole. No individual member has authority to bind or act for council. And similarly, the way the committee is constituted, the committee as a whole must make decisions as a collective, as an appointed body of the council. Members come together and make decisions as a whole. So one member of the committee, unless there's some authority provided to that member, doesn't necessarily speak for the committee. So it's important that the committee come together as a whole and make these decisions and discuss these important issues. Consultation. Oh, sorry, we'll go back. Consultation can take a number of different forms, and that largely depends on the context of what's being discussed, the subject matter, and council's needs, right? So that might take the form of a meeting at which, I'm just thinking of examples, a meeting at which certain members of council appear as a delegation before the committee, or vice versa, where the committee authorizes a member of the committee to delegate before council. It can also take the form of a report, a written report, but by and large, it's going to be the written direction based on a vote that's taken at a meeting that's provided to council. So generally, council will provide direction to township staff that input or consultation is required from the committee. And this is again based on the advice that council's given about its legislative obligations. The committee will then hold a meeting, discuss the matter under consideration, and vote to provide input and vote to give advice to council on the matter. And then the recommendation from the committee will be provided to council in a council agenda for council's consideration. And again, council is the ultimate decision maker in a municipality, and so that advice and input must be considered by it in making its decision. We can go to the next slide. So with that, the structure of a committee and how that functions within a municipal corporation, the committee can advocate for accessibility by providing unbiased advice to council on the matter of consultation or the matter for which input is required, taking a broader view of accessibility needs as opposed to focusing on one issue, ensuring familiarity with AOTA and the integrated accessibility standards under it, and learning about the committee's role in the township's processes to understand what potential constraints the committee might have and how the committee can affect real change within the township. So the next thing we'll focus on is review of site plan drawings. So this is one of the committee's functions under AOTA. The committee has the ability to select certain site plan drawings for review and provide advice and input to council and the township. So a bit of background if the members of the committee aren't quite familiar with site plan approval and how that process works. The Planning Act in Ontario is what governs the development of land, and there are a number of approvals required in order to, for instance, build a home, build a new commercial building, things like that. Under the Planning Act, there's a provision that requires the approval of what's called a site plan. And so this is essentially a drawing or a mock-up of the detailed minutia of how a site is going to look and how it's going to function when it's ultimately built out. So this will have things like the buildings, elevations of the buildings, where sidewalks are going to be located, where driveways are going to be located, how trees are going to be planted around. It's essentially the detailed design of a site. In accordance with the township's bylaws, the township will receive and review these applications for site plan approval. What will happen in that process is there will be a pre-consultation meeting with the applicant, and essentially this is to identify certain application requirements, some study that might be required. Township staff and other applicable agencies within the township that operate within the township will review those proposed drawings and the other reporting studies and provide comments on them. And the site plan drawings are ultimately approved by the chief administrative officer, so that's it here, with or without conditions that may be imposed. And in addition, there might be a requirement to enter into an agreement to secure certain things within the approval. That review process is subject to a statutory timeline. And on my last recollection of like that provision of the planning, I believe it's 60 days from when the application is filed. So under AOTA, the committee may review certain site plan applications in the overall bailiwick of the committee's mandate and the role of the committee. It's not necessarily an open-ended review for the merits of development or whether this particular type of development should be located on one site or another. The committee's review it should be focused and constrained to or limited to what the committee's purpose is, which is to ensure that potential barriers are addressed and removed appropriately. So the committee in that or in thinking of that role might not want to review every single site plan that's made to the municipality, because we can think of certain facilities, essentially private homes, for instance, or private buildings that the accessibility concerns that the committee is established to address, those might not necessarily be pertinent to those. So in performing this role, the committee might wish to choose which types of development it'll review. So certain things like public buildings or buildings for which the public would frequent or access. The committee should also consult with township staff to determine what criteria should be used when reviewing these site plan drawings and develop some consistent form of review and reporting so that the committee's input can be forwarded to township staff in processing the application. There's no fixed protocol that's set out in AOTA for how this review is undertaken. And with that in mind, I understand township staff are working on developing something of a protocol or a process for this committee based on what other municipalities in the area are doing and best practices to facilitate the committee's review of site plan drawings. And that review, I think, is still in the works. So there's still some time for that to be settled, but the committee will be advised of what that process will look like. It's important to remember when reviewing site plan drawings that under AOTA and under the Planning Act as well, the committee doesn't have the power to approve or reject the development proposal or impose conditions. That role falls to the township through the chief administrative officer. But keeping that in mind, what the committee does is provide valuable input as a backstop effect to ensure the accessibility of the design of certain buildings, which might ultimately lead to revisions to the drawings or conditions that are imposed on approval or things that are included within a site plan agreement. Okay, part 4, so the decision-making process of the committee. We're going at a pretty good clip here, actually. So as a deliberative body, as an appointed body of council, the committee exercises its powers by making collective decisions, so coming together and voting. There's sort of an old adage in governance, municipal governments, that council speaks with one voice, and that's the same of the committee. The committee speaks with one voice because it has to make decisions as a whole. So individual members don't make decisions on behalf of the committee. The way decisions are made is that all members will come together, discuss and deliberate, and then a vote will be taken on either a decision or direction that's provided. In order to do that, of course, the committee has to hold meetings and engage in deliberations and discussion on the topic at hand. Even though the committee's parliamentary procedure proceeds by majority vote, building consensus is an important thing on any deliberative body. You want to make sure everyone's perspectives and voices is understood before making a decision, and that everyone has an opportunity to provide the input that they wish to on a particular matter. With that, attendance and active participation at meetings. I know we're in a small room, so you can't really hide and watch a video on your laptop or anything like that. But active participation, being engaged in discussion, making sure you're voicing your opinion on matters, that's the crucial responsibility of members of this committee. And what the terms of reference provide in line with that is that if a member misses 4 meetings or there are 4 unexcused absences from meetings in a term, council might remove the member from that committee. The conduct of meetings, so the sort of the rules of parliamentary procedure, which can be flexible in certain contexts, especially for a committee. Nevertheless, they're governed by council's procedure bylaw. Every municipality is required to adopt one, and that sets out the rules for calling of a meeting, the location of meetings, how they're to take place, roles and responsibilities within a meeting, certain things. But I'll provide a high level overview of what I think are the most salient points for the members of this committee. So for The committee meetings take place in accordance with an approved meeting schedule, and in accordance with the committee's terms of reference, there needs to be at least 4 meetings a year. That's the minimum. That scheduling will be dealt with through the clerk. A quorum of members or a majority of members must be present at the meeting in order for the committee to conduct business. So for a committee of 5 members, 5 individuals, that number is 3. So if there are any fewer than 3, a meeting can't take place. Meeting agendas are what focus the committee's discussion and deliberations, and those are prepared by the clerk in consultation with the committee based on items of business that will come forward. There are rules for adding new items or adding addenda to the agenda if there are other items of business. And then in the structure of an agenda, there are also other business or other items of business that can be raised by the members of the committee. Meetings are presided over by a chair, which the committee will have to elect a chair and is it called a vice chair? Vice chair, okay. Some municipalities call it a deputy chair because that aligns with like a deputy mayor position, but vice chair. And then the procedure bylaw also sets out rules of debate. So at a very high level, how it works is that there's a running speakers list. So the chair is responsible to maintain a list of who has put their hand up first. So like you use Teams or Zoom, there's a little icon beside the hand, which is kind of nice to track it, but if we're in person, you'll just jot down the name. And then the members will take turns in order of the speakers list to make comments or provide their input or opinion on the particular agenda item. Once that's done, if there's a decision that the committee wishes to vote on or present, a member will have to move a motion. And so there'll be a mover and what's called a seconder. The seconder is the formal way to get something to a vote, right? So if there's no seconder, that motion expires on the floor, dies on the floor. So decisions are made by voting on a motion, moved and seconded, and passed with the support of majority of members present at the meeting. If a motion's on the floor, that motion can be amended, but there needs to be a separate request to amend that. So meetings are presided over by a chair who will be elected by this committee. And I think we have that on the agenda for today as well, right? So the chair has additional responsibilities under the procedure bylaw, and the chair plays an important role in facilitating the committee's meetings. They preside over meetings, including opening the meeting, calling the meeting to order, reading the land acknowledgement as well. And the chair also announces business of the committee based on the structure of the agenda and where the committee is at in that particular meeting. The chair will also call for a vote and decide the results of the vote, and usually this will be by show of hands. For other less contentious or more procedural votes, for instance, motion to adjourn, things like that, that might just be done by either consensus or strong vote unless there are any objections to that. The chair also enforces the rules of debate. I use the word enforce because I think it's the technical parliamentary term, but that's just making sure that everyone has an equal opportunity to participate in the committee's deliberations. So so that's the committee's sort of meeting structure and how meetings themselves will take place. An important aspect of how meetings take place is what's called the open meeting rule. In Ontario, under the Municipal Act, every meeting shall be open to the public, or is required to be open to the public, except if there's a certain subject matter exception that applies. The rationales for this are twofold. First is to increase public confidence in local government so that the public can see, is transparent, and can understand how decisions are being made, and to prevent secrecy in municipal decision making. That being said, there are certain exceptions to the open meeting rule when there might be some legitimately sensitive material or discussion that's going to be had. And there are 14 subject matter exceptions that are set out in the Municipal Act that permits a council or a committee to hold a closed meeting. What they're designed to do effectively is protect against the disclosure of sensitive information that either belongs to the municipal corporation or a third party. So one exception, for instance, is the acquisition of land by municipality. So if you can think of the analogy of buying a house or buying a home, perhaps you and your spouse are talking about what you like about the house. Well, I like it's a 3-car garage, a beautiful facade, but I'm not too keen on the backyard. It needs some work. You wouldn't want to discuss that in front of the vendor or the seller of the house, because they're then going to know what your position is, and that can compromise your bargaining position. And the same goes for a municipal corporation. Municipal corporations have to make decisions through council, and if council were required to talk about a pending acquisition in public, a lot of information could be disclosed that could end up compromising the municipality's interests and then affect the public interests. The exceptions under the act, though, are rarely engaged by the work of the committee. So the example that I've just given about the potential acquisition of land, that might be a circumstance where the committee will hold a closed meeting, because again, if council is required to consult with the committee on the acquisition of a property on accessibility standards, then the municipal address, even the fact that the municipality might wish to acquire that property, that would become public knowledge if the committee was required to have an open meeting in that circumstance. That guidance or the determination on whether something qualifies for a closed meeting would be up to the clerk. The clerk will provide the committee advice on when certain things can be discussed in closed session, but for the lion's share of the committee's work, those are properly open session discussions. There's some other procedural rules that apply when going into closed meeting, and again, this is where the clerk will provide valuable assistance to the committee. Before going into a closed session, the committee or council must pass a resolution stating the fact that the meeting will be closed to the public and the general nature of what will be discussed. And again, that's something that the clerk's office will assist with. And during closed session, there can't be any voting or substantive decision-making on the topic. The only exception to that is the committee can vote on procedure, on parliamentary procedure, on moving things or adjourning or taking a recess, or it can provide direction to municipal staff. The clerk will provide, again, advice to the committee on whether a closed session meeting is permitted in circumstances and the procedural requirements for meeting in closed session. So based on that, and based on some closed meeting investigations and developments in the law that have come out, I wanted to talk about two potential pitfalls for members of the committee. And these are informal gatherings and serial messaging. So the definition of a meeting under the Municipal Act that would be subject to the open meeting rule, it depends on how many members are present, and it also depends on whether the discussion materially advances an item of business that could come before the committee, and this also applies to a council as well. So for instance, a coffee shop discussion with 3 of the 5 members would constitute a quorum. There's a majority of members present. And if those members are discussing some item of business that's going to come forward to the committee, that could constitute an unlawful closed meeting because the notice of that meeting wasn't given, a resolution wasn't passed. So it's important to keep that in mind. That's not to say that 2 members can't discuss an item of business or might not be able to talk to each other, so long as there's not a quorum of members present. So the magic number for this committee is 3, then that should be perfectly fine. Another common pitfall that I think in the present day we see pretty often that can get members of council, members of committee in trouble are serial emails, texts, calls, voicemails, that sort of thing. So there have been closed meeting investigation reports that found where a quorum or majority or all the members of council are copied on an email thread or committee members copied on an email thread and they're exchanging information or opinions about an item that's coming forward for business, more than just something for their information. That can constitute a breach of the open meeting rule. Again, it depends on whether the discussion materially advances, is the standard, materially advances an item of business, which essentially means laying the groundwork for making a decision. So those are 2 common trappings that some committees get caught up in. But I think members with the two takeaways from this. To the extent there are any emails or text messages exchanged with the members, members should avoid talking about substantive decision making. Saying something like, we'll see you at the meeting tonight, or yeah, I noticed this is on the agenda. That should be okay. That shouldn't be an issue. And then the second are informal gatherings that take place outside of a formal meeting that's all legally constituted. Okay. So talk about municipal ethics. Municipal ethics is a growing field, I think, in the last, say, 5 to 10 years, because the expectation of the public has been raised. Not to say that in the past ethics have formed a low ranking or a non-issue, but members of the public expect a level of sophistication to municipal government in the present day, and that's where ethics come to play. As a member of this committee, you're an individual representative, you're a private citizen, but you're also a representative of the township when conducting committee business, and that has to be kept in mind when carrying out the committee business. There are certain rules and processes that apply to all members of council and all members of all committees of the township. And the three areas that I want to take the committee through very quickly are the confidentiality agreement that's been circulating. We can spend a moment and go through that. The respect in the workplace policy and the municipal conflict of interest act, which you heard the clerk refer to in the opening remarks in this meeting. But first we'll talk about confidentiality. So I've talked about the open meeting rule, and I've talked about the inverse side, which is protecting sensitive information that might end up compromising the public interest or the interests of the municipal corporation. As a member of the committee, you might have access to information that the public does not, information that's considered to be confidential. So one example that I've used before is consider the township's purchase of a new building, right? So the fact that council wants to purchase a new facility, say for a community center or for any reason, perhaps a new township hall, municipal offices, the fact that council wants to do that is considered confidential information because council is entitled to protect its bargaining position in that transaction to make sure it gets the best deal for the municipality, which means the best deal for all of the residents of the municipality. So that's just one example. So that type of information, there are two aspects to it. There's information that's protected from disclosure at law. So under MFIPA, the Municipal Freedom of Information and Protection of Privacy Act, there's certain exemptions where documents or records in the possession of a municipality don't need to be disclosed to the public because there's some recognized exception to the rule of transparency. And there's also personal information, which is information about an identifiable individual. And then there's also information that safeguards the interests of the municipality. So this is something like a bargaining position that I talked about, closed meeting information. Maintaining confidentiality is often referred to as the cardinal rule of the obligations, the ethical obligations of a member of municipal council. And that's because that information, as a member of a committee or council, you're the custodian of that public trust in that document, in that record, in that information, even if it's not recorded. And disclosing that improperly or without authorization from the appropriate authority could result in some compromised position of municipality or some third party, which could give rise to liability. So with that, the township's practice, and this is a practice in almost every municipality that I've ever worked with, is that members are required to review and sign a confidentiality agreement, which I understand has been circulated. I don't think I have a copy. We can certainly go through it, but it's quite brief, and the obligations of a member of the committee. I'd like to draw your attention, I think, to the 1, 2, 3, 4, the fifth paragraph. So it's kind of in the middle of the page, starting with "I further acknowledge." The first is about the municipality's obligations under law to protect and preserve certain information. And then the fifth paragraph would have provided that you further acknowledge and understand that in the course of carrying out your duties, you might have access to and maybe dealing with records containing confidential or personal information, which reveals not only information about the identity of the person who is subject to the records, but also the identity of the person who's provided the information. So the confidentiality agreement essentially obligates you not to disclose in an unauthorized manner any information that you might get that's marked as confidential or discussed in the closed meeting of the committee. So these agreements have been circulated. I believe the clerk will collect them at the end of the meeting. But I just wanted to highlight why that agreement is important. Perfect. So the next part of ethics is the respect in the workplace policy. The township has, like many other municipality or employer, municipality has adopted a policy that deals with protecting its employees from harassment, violence, and sexual harassment in the workplace. As an employer of how many municipalities does the township have? Employees.
Oh, it's right. 38.
38, there we go. The employer of 38 employees. Municipality has obligations, particularly under the Occupational Health and Safety Act, to protect its employees from harassment and violence. So the interactions with township staff that you might have in a meeting or outside of a meeting, those would be governed by this policy. So some key terms in the policy: harassment is force of vexatious comment or conduct that is known or reasonably ought to be known to be unwelcome. Sexual harassment includes conduct or comments of a sexual nature that the recipient doesn't welcome or that offend him or her. And discrimination includes conduct or comments based on protected grounds from the Ontario Human Rights Code, which the recipient does not welcome or that offends him or her. Important in all these definitions is that the intent in making this comment does not matter to this definition. So it's the impact of those comments that are made. Another key term is workplace violence, which is physical force that could cause injury, an attempt to exercise that physical force, or a statement or behavior that is reasonably interpreted as a threat to make physical force that could cause an injury. And I think that policy has also been included in the agenda package, so members will have a copy of that and have an opportunity to review and consider that further. Okay, so we're on the Municipal Conflict of Interest Act, which I think is the last part of the last segment of our session. You heard me first read out, I believe it was the second or third item of business, which was disclosures of pecuniary interest. So the MCIA, for short, it governs members of council and committees and other local boards' decision-making process where they personally have a financial interest in the outcome of a decision, whether it's a gain or a loss. The MCIA operates around what's called a pecuniary interest, and that word isn't defined in the statute, but the case law interpreting the MCIA provides that a pecuniary interest is any interest in a matter before the decision maker concerning or consisting of money, or an interest that has some monetary or financial value, positive or negative. They must be definable and real and not theoretical or hypothetical. And under the statute, there are three different types of interest, which I'll explain a little bit more. There are direct pecuniary interests, indirect, or deemed pecuniary interests. So a direct pecuniary interest is where you yourself, as a committee member, could experience an immediate and non-deviated economic impact as a result of some decision that's made by the committee. So this would affect or impact your own personal finances, again, positive or negative. An indirect pecuniary interest is a financial interest that arises through some other entity that's related to you. So this includes a corporation of which you're a shareholder, a director, or a senior officer. So these are private corporations. It can also apply to publicly traded corporations where the member has a quote controlling interest. So these are large portions of the outstanding shares of a corporation, or if the member is a director or senior officer of that corporation. An indirect financial interest can also arise where the member is a member of a body. Body isn't defined, but it's been interpreted quite broadly to include certain things like service organizations, not-for-profit corporations, clubs, things of that nature, or entities of that nature. And then lastly, where the member's employer or a business partner has a financial interest in the matter to be discussed. And then the last one is a deemed financial interest, and this is an interest that arises through a family member. So this can be a parent or a spouse or a child of the member. If the parent, spouse, or child has a financial interest in the matter and it's known to a committee member, that's a deemed financial interest. I mean, you're deemed to have the financial interests of those individuals. So having a pecuniary interest or having some financial interest, that's not wrong. That happens, and the MCIA also has a principle section that recognizes that individuals who serve on a public body come from many different walks of life and may have different business interests, and that provides valuable input to the decision-making process. But the obligations under MCIA are related to how you deal with those financial interests in the decision-making process. Ultimately, members of council, members of committees, they're elected and appointed to serve the public interest and not serve their own private interests. And that's what the act is trying to get at. So the obligations that are set out in the MCIA, when members present at a meeting where a matter that involves a pecuniary interest is being considered, the members are required to disclose that interest and the general nature of that interest prior to consideration of that item of business, not take part in any discussion or voting on the matter, and not attempt to influence the decision that's being made by the committee. The MCIA also prohibits attempts to influence municipal officers and employees on decisions or recommendations that might be made by them, either decisions made entirely by that officer or recommendations that are provided to council. There are a number of recognized exceptions under the Act where those obligations don't apply. And they can be quite specific. So for instance, councillor's remuneration or a member of the committee's per diem or expenses, those are all expenses or financial interests that are incurred because that individual is a member of council. So that's an example of an exception. The two biggest ones that are relied on quite often. The first is where that interest is an interest in common with electors generally. And the second is where the interest is remote or insignificant. So I'll explain those two in a little bit more detail. The interest in common exception applies where other electors within a certain geographic area, it could be the broader township or the entire boundary of the township, or within smaller locations, so say a neighborhood, where each resident or each elector within that geographic area, they all have a financial interest. So an example of this that comes from a case, say there are sewer or water main upgrades on a particular residential road. And say services are being extended for the first time. Previously, everyone was on private services or septic and well, that might have the effect of increasing your property value because now you're on municipal services, not private services. You would have a financial interest, right? Because your property value could increase. That being said, every other resident on that street within that catchment area would have the same interest. They'd have the interest of a potential increase in their property value. But the MCI recognizes that this is okay because your motivating reason for participating in decision making is the overall public interest and not just your own discrete private interests. The second one is where the financial interest is remote or insignificant, and the test that's been developed under the MCIA by the courts is whether, I'm sort of paraphrasing from a case, but it's whether or not the interest is so remote or insignificant that a reasonable third person being apprised of all of the circumstances, so all the circumstances of the council decision making, of the vote, of how the program is structured, of your own personal financial interests, would not conclude that the member's private interests motivated their decision making. So these are principles, or these are things that could potentially come up, and each member has an obligation to review the agenda and identify, or at least be aware of when a potential financial interest could come up. So one example might come up where, for instance, the committee has a role in reviewing site plans. And if your employer, we'll take sort of a fictional employer, wants to build a new facility or new factory in the municipality, and that site plan is selected for review, that review process might end up leading to certain modifications to the design or the layout of the site, or conditions that are imposed, which would make it more costly to build the project. Well, that would be an indirect financial interest under the Act, because your employer has a financial interest and you have that indirectly as it relates to that decision-making item. So again, there's nothing wrong with having a pecuniary interest or financial interest. And in fact, to some extent, the MCIA recognizes it's good that members of the community that serve on public bodies have this involvement in business and the community. But again, the obligations are to recuse yourself from decision-making so that your personal financial interests aren't affecting the outcome of a decision. Sort of at the end of the day, the takeaway for this comes from a book written by the former clerk of the city of Ottawa, actually, Rick O'Connor, in a book on or handbook, if you will, on the Municipal Conflict of Interest Act. And what Mr. O'Connor says is the question that members should ask themselves when considering whether or not you have a financial interest is, do I or any party whose interests I am deemed to have, so deemed being parent, spouse, or child, or the indirect interests, so your employer principally, and any corporations that you might be associated with, do those individuals stand to gain or lose arising out of the vote in question, or does the vote have the potential to affect my financial position, whichever way the vote goes? That's sort of the guiding question, or the guiding light to ask yourself if there's ever a question. In practice, sometimes it can be difficult. And my advice to members, my advice to municipalities is often, when in doubt, declare a community area interest, because you're better off erring on the side of caution. Okay, so that brings us to the end of the presentation. So we've left lots of time for questions or items of discussion before we go on to the next the next few items of business.
I have a quick question, Dawn, kind of going back to the very beginning of the presentation, more of a high level question. So with the committee, like really, like council is looking for the committee to provide kind of feedback based on like personal experiences as opposed to being like experts with the act or the regulation.
Yeah, absolutely. Yeah.
So then I think my next question is, like the interpretation of the act or the interpretation of the regulation, like where does that sit within the committee? Like using, like looking at the
That's a good
example of,
question.
like say barrier free. You know, it may be hard for, say the planning personnel to kind of anticipate, like what does barrier free really mean or what does that look like?
Yeah.
So I'm just, I guess, like, just for maybe my own knowledge is, what is the delineation between, you know, the committee's advice and feedback, like in that kind of arena?
Yeah, no, that's a fantastic question, right? Because I think the regulation is written in an aspirational way,
Yeah.
as opposed to very prescriptive, like the building
Yeah.
code, for instance. So with that, I think it's a joint effort, or it's a team effort. So there are certain aspects that municipal staff will be reviewing and interpreting, but it all depends on the particular context, right? So staff might have a particular view or input to provide to the committee. The committee might also have input, and that input all comes together. There's a synthesis of that information that's then provided to council for the ultimate decision on behalf of the municipality.
Right, okay. So the committee isn't really expected to, like internalize the act or the regulation and
Yeah.
and kind of, you know, filter our maybe feedback through that, but really just focus on like our experiences of, you know, living with disabilities and
Yeah, absolutely.
and how that may influence decision.
Yeah, that's exactly right. And I think you're not, as a member, you're not expected to have this deep ingrained
Yeah.
knowledge. And I think there's quite a few consultants that work in this, where there are specific or detailed questions about a very particular or nuanced design of something. The committee members aren't expected to have that, but what the expectation is that you review that information and provide advice based on lived experience, based on information that you might know from being a member of the community, all filtering together and synthesizing in that ultimate decision.
Thank you.
You're welcome. That's it.
You mentioned earlier on in the presentation about 4 meetings per year minimum. And then you made some comment about if you missed more than 4 meetings in the term. Now, are you talking about, typically this would be a 3-year or 4-year term, election to election, this time it's not going to be. Was there reference to the 4-year term? If you met,
I think that it would depend on how we're going to interpret the terms of reference for this year. I think it would be prorated. I think that would kind of be the fair way to understand.
just trying to understand what's going on.
Yeah, so I think that would work out to be, they were about halfway through the term, so that would be 2 years. Or
We will
1 year,
go to the end of the, pardon, Councillor Wood?
1 year, 3 months.
9 days, right? So I think it would be prorated for the purposes of this year, because the committee's just been constituted.
Does anyone have anything before? So that's maybe a question perhaps more so for you, for you and your team. And John used the term selected multiple times in the presentation. So I'm assuming that, like as a committee, we're not responsible for kind of staying informed of all of the applications we get and, you know, coming forth and asking to review things like we could, I think, anticipate that your process would do that for us.
Absolutely,
Yeah.
we will bring those to you. Yeah,
Mhm.
absolutely.
Yeah, and I think part of that as well is that protocol that's being
When we go through-
developed as well.
Yeah,
That'll
that's
provide
what, that's, yeah,
Yeah,
protocol.
detail
the protocol,
of the
yeah,
process for selecting those plans and reviewing them, right? Because you could provide criteria to say, look, we don't need to see
Yeah.
absolutely everything. We're more interested in seeing particular types of development,
Yeah.
facilities, location, that sort of thing.
Like things like sidewalks,
Yeah.
like, you know, those things would be important to residents, but other things, like you mentioned, I think private developments and whatnot,
Mhm.
you know, is the committee going to, I don't know, maybe like, but, you know, it's kind of thinking about from a holistic perspective of the whole community, where can the
Right.
committee best provide, you know, some support?
Perfect.
So your definition of an open meeting?
Yeah.
Is it gonna be if we live stream it?
Yeah, so it depends. So live streaming, this has all happened through COVID, right? So live streaming is the one way that you can make a meeting open to the public. Open to the public just means that any member of the public had an opportunity to observe decision-making in real time. So that can be fulfilled in any number of different ways. It could be doors are open, come on in and have a seat. It doesn't necessarily mean live stream where there's an electronic meeting where it's only being held by virtual means like a Zoom meeting or a Teams meeting. Part of the requirements of the act is that meeting, that Zoom meeting has to be viewable by the public. It doesn't mean participation by the public, but it means that the public can see what's going on in the confines of that meeting.
Even if they can't participate?
Yeah, because the
That's
open
considered
meeting,
open.
the open meeting rule does not in any way entail participation by the public, and there's a case law on that as well. There's a divisional court case that said the open meeting rule is not about participation. No member of the public has an absolute right to speak to a council or committee. It's all about observing the process of decision making in real time. There are other ways for members of the public to get involved in decision making. That's all set out in council's procedure bylaw. So council will decide how it wants to allow the public to take part in meetings. Principally, that's through deputations, letters, things like that.
So just in context, do we do that with any other committees that there's an open door policy that somebody can come in and sit down as long as they don't say anything?
We've done that with the sustainability committee.
Yeah.
Yeah, we've had people attend,
Mm.
and I think,
Yeah,
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 Yeah.
Mr. Hacknell, or Valley
Yeah.
Trails, all of them,
Yeah.
Yeah.
They're all open, we have members come.
everything I see is past tense on YouTube, so.
I think, correct me if I'm wrong, and I don't wanna get myself in trouble, but if a member comes and they ask to say something, it is like the chair can, welcome them.
Within the confines of the
Yeah.
procedure bylaw, so long
Yeah.
as there's a procedure in place for that participation.
Yes.
Yeah.
A member of the public can be recognized and talking.
Similar to a council meeting, there'd be a support mover and a seconder to allow that person to participate in the meeting, just like we do at council. When there's additional member council that want to participate for a deputation, let's say there's an extra, yes. Any other questions?
I don't know where you fit into the hierarchy of this whole government thing, and you're not from Peterborough, you're not related to the Papas here.
No,
Okay.
no.
Um,
Common,
that's fine.
kind of
That's
submit
fine. That's fine.
the Greeks.
I was curious there, because there's a couple of things that you mentioned that aren't defined, but they're well understood.
Yeah, yeah.
And that drives me nuts with government, with the
Yeah.
idea that they
Yeah.
leave everything so vague that nothing really applies.
Yeah.
The one that's always jumps out in front of me is affordable housing. Oh, we don't have a definition for it.
Yeah.
But we think we know what you're talking about, and they don't. So why this not defined?
That's a good question, right? So I didn't write the.
I-
so I can't really
I-
tell you, but, what my guess or my answer would be, we have guiding principles or guiding doctrines that are set out in law. But a lot of that depends on the context and it depends on the factual circumstances that come forward. So what might be a financial interest in one circumstance before one committee might be different at a different local board or a different council meeting. There's a general understood idea of what that means and what the members' obligations are, and in particularly under the MCIA, right? Financial interest, I think we all generally know, but the devil's in the details, right? So if your uncle left you the shares to his corporation, but you haven't seen them in years, you didn't know you own them. It's those sorts of really tricky things that depend a lot on the factual circumstances. But the courts have given guidance about how we're to understand or how we're to work with it. So there's at least an arguable basis for how you carry out decision-making process.
And that interpretation is done by who?
Principally, it's the member's obligation to figure out whether, as a member of council,
Mhm.
a member of council can seek advice from the integrity commissioner about that sort of thing. It's ultimately up to the member of the body to determine whether or not they've got a pecuniary interest. Someone could challenge that determination. They can make a complaint to the integrity commissioner, or they can apply to the court for a determination that someone's violated the MCIA. Not that it should be any reason.
Yeah, I would just.
No, very,
Yeah.
very, very infrequent that does that happen. So don't worry about that.
Good. Any other questions?
Great.
Yeah, no, okay.
Thank you, that was very thorough.
Thank you.
Great, thank you. Thank you very much, John. What we will do now formally is we will take a motion to accept our committee orientation and our training information and the additional documents that you've been provided. So I will need a mover and a seconder. Perfect, Leslie, Paul, great. Okay, good. So the next item on our agenda will be the appointment of our chair. Has anyone given consideration to wanting to put their name forward as chair or vice chair?
I would be interested in putting my name forward for the chair.
Okay, great. Do we have a seconder? Great, Leslie, great, thank you.
I, sorry, point of order.
Yes.
And this is totally fine. I
Yeah.
think generally when you appoint a chair, someone nominates themselves, you
Yes.
need another
Seconder.
mover, so we need another mover.
So I
say,
move that we need a
Leslie
second.
Okay.
Seconder.
Perfect,
There we go.
thank
Perfect,
you,
perfect.
thank you. Perfect, and then for vice chair,
Should we vote on the first one? No,
all of, yes, I'm sorry for, yes, all in favor, thank you, Councillor Martin.
pick up a few things along.
I'm sorry. I should know. Yeah. Can you help me this?
Yes.
Roll reverse, all in favor?
We're all good.
Councillor Burnt, great, and carried. Okay,
Congratulations.
thanks, congratulations. And for
Thank
vice
you.
chair?
Anyone wanna do it? No? I mean, I'll do it for now. Like, for now, I mean, for the rest of the 1 year and 3
Term.
months, yes.
Okay,
Yeah.
and can we have a mover to support that? Perfect, Paul. Okay, Lucy, perfect, and all in favor? Perfect, carried. Wonderful. So the next, good, Julie, perfect. I do have to keep me alive. So the next meeting date, that we are proposing, it will be August 27th. And then from there, we will work on a final schedule to propose.
What day of the week is that?
It'll be a Wednesday as well. We
I-
find that will
I'm
not,
not available on that day.
okay,
Not that that should hold you guys up, but so it's one of the, I just know I have an appointment on that day. But, yeah.
the,
If we can make it not a Tuesday or Wednesday, that'd be ideal for me.
okay. So maybe what we'll do is we'll chat and look at some meeting dates and time schedules that work with the group, and then we'll work on something. Okay, I think that's fine. Yeah, I'm scared now. Okay, so I think other than that, we will take a motion to adjourn our meeting
Before we did that,
for council.
could I ask how many more meetings you're scheduling in this projected to?
We anticipate to schedule for the 4 meetings for this year. We have to work on a few.
calendar year.
Calendar year, yes. Between now and December, we're hoping to get a meeting in the next, we also, yes.
And then 4 in the next calendar year before the October election. Well, theoretically. you have to do
Theoretically,
that.
yes, yeah.
Yep.
Not just that based on the perceived, not,
Yeah, that's what I'm
Okay.
asking.
that's anticipation. We do have a lot of work to do on this committee too, so that's why we're hoping that we can get the meeting scheduled.
Excellent.
Good, yeah. Any other questions before we adjourn? Okay, I'll get a mover and a seconder. Adjourn, Leslie. But the time is, let me know.
2:05.
2:05.
Wow, that was really very speedy.
So we need to vote on that.
All in favor?
Thank
Adjourn, carries.
you.